Tuesday Cafe. I'm Sean Canan, and we are broadcasting live on January 14th from the studios of WMNF in Tampa. And we're going to talk about TikTok and whether that platform will still be allowed in the United States in a few days. Here's a few sentences from the AP that I want to let you know about. So the Supreme Court, the U.S. Supreme Court, seems likely to uphold a federal law that would ban TikTok in the United States beginning this Sunday, unless the popular social media program is sold by its China-based parent company. Hearing arguments Friday in a momentous clash of free speech and national security concerns, the U.S. Supreme Court justices seem persuaded by arguments that the national security threat that's posed by the company's connections to China override concerns about restricting the speech either of TikTok or its 170 million users in the United States. Arguments lasted more than 2.5 hours. We're going to hear about 55 minutes of those arguments today. You'll hear that Chief Justice John Roberts identified as the main concern in the case TikTok's ownership by China-based ByteDance and the parent company's ties to Chinese government's intelligence operations. We're going to hear segments of those arguments right now. You can let me know what you think by emailing dj@wmnf.org. Do you use TikTok? How will the ban affect you? In this first section, we have here the justices question an attorney for TikTok, Noel Francisco.
We will hear argument this morning in case 24-656, TikTok versus Garland, and the consolidated case. Mr. Francisco.
Mr. Chief Justice, and may it please the court. Under the Act, one of America's most popular speech platforms will shut down in 9 days. That shouldn't happen for 3 reasons. First, TikTok Incorporated is a U.S. company speaking in the United States. The Act requires it to go dark unless ByteDance executes a qualified divestiture. Whether you call that a ban or a divestiture, one thing is clear. It's a burden on TikTok's speech, so the First Amendment applies. Second, the Act is content-based from beginning to end. It applies only to social media platforms that have user-generated content except for business, product, and travel reviews. Within that content-based universe, it singles out a single speaker for uniquely harsh treatment, and it does so because the government fears that China could, in the future, indirectly pressure TikTok to disseminate foreign misinformation and propaganda. Finally, the Act can't satisfy any standard of scrutiny. The government has no valid interest in preventing foreign propaganda, and its fallback that it seeks merely to prevent covertness makes no sense, since that could be addressed with a risk disclosure. The government's real target, rather, is the speech itself. Its fear that Americans, even if fully informed, could be persuaded by Chinese misinformation. That, however, is a decision that the First Amendment leaves to the people. Given that, the government's data security rationale cannot independently sustain the Act. It is also grossly under-inclusive and ignores the most obvious, less restrictive alternative, simply banning TikTok Incorporated from sharing any sensitive user data with anyone. In short, this Act should not stand. At a minimum, you should preliminarily enjoin it, which will allow you to carefully consider this momentous issue and, for the reasons explained by the President-elect, potentially moot the case. I welcome your questions.
Exactly what is TikTok's speech here?
TikTok, Your Honor, uses an algorithm that in its view reflects the best mix of content. What the Act does is it says TikTok cannot do that unless ByteDance executes a qualified divestiture. That's a direct burden on TikTok speech, much less of a burden than the one that this court struck down in the Simon & Schuster case, where all the author had to do was take a certain amount of proceeds and put it into an escrow account for a short period of time to satisfy a civil judgment.
So why does a restriction on ByteDance, which is not a citizen, is not located in the U.S., a restriction on TikTok?
Because what the law says to TikTok is that TikTok, you cannot use the algorithm that you prefer to use unless ByteDance executes a qualified divestiture. So the law therefore falls directly on TikTok itself. It imposes a burden on TikTok speech, again, a much more significant burden than the one that was struck down in Simon & Schuster.
So you're converting the restriction on ByteDance's ownership of the algorithm and the company into a restriction on TikTok speech. So why can't we simply look at it as a restriction on ByteDance?
Because I think the burden falls directly on TikTok, and I can use a hypothetical that helps illustrate the point. Suppose that China used its leverage over Jeff Bezos's international empire, including his Chinese businesses, to force the Washington Post to write whatever China wanted on the front page of the Post. Surely the government couldn't come in and say, Jeff Bezos, you need to either sell the Washington Post or shut it down. That wouldn't just violate Mr. Bezos's First Amendment rights. That would also violate the Washington Post's First Amendment rights, because they are ultimately the one that's suffering the burden under that law, because they have to go dark and close up their books.
Counsel, you began by saying this is a U.S. company operating in the United States.
Yes, Your Honor.
But the ultimate company that controls it, ByteDance, was found by Congress, and I quote this, to be subject to Chinese laws that require it to assist or cooperate with the Chinese government's intelligence work, quotes, and to ensure that the Chinese government has the power to access and control private data that the company holds. So are we supposed to ignore the fact that the ultimate parent is in fact subject to doing intelligence work for the Chinese government?
Well, Your Honor, I don't think you are supposed to ignore that at all, but I also don't think that it changes the analysis for a couple of reasons. Look, TikTok and...
Well, just hold a second. Well, as I said, you began by saying this is a U.S. company operating in the United States, and it seems to me that you're ignoring the major concern here of Congress, which was Chinese manipulation of the content and acquisition and harvesting of the content.
Sure. And I'll start by saying that TikTok Incorporated is a United States subsidiary operating in the United States with its own set of free speech rights.
Do you dispute the fact that ByteDance has ultimate control of TikTok in its corporate organization?
Yes, Your Honor, I do dispute that, but I also don't think that it matters, because even if China could exercise overwhelming power against TikTok versus ByteDance, I don't think it would change the analysis. And I can take that Washington Post hypothetical and ratchet it up a little bit to help illustrate the point. Let's suppose that the Chinese government had actually taken the Bezos children hostage, and it was using that leverage in order to force Bezos and the Washington Post to publish whatever they wanted on the front page of the Post. So China effectively has total control. I still don't think that Congress could come in and tell Bezos either sell the Post or shut it down, because that would violate Bezos's rights and the Washington Post rights. Maybe what they could do is come in and say, you need to disclose the fact that you're under this amount of coercion, so that the people who are looking at the paper understand it and can make their own assessment. But I think the First Amendment rights of both Bezos and the Post would be directly implicated, notwithstanding that China in that scenario has effectively total control over what gets printed in the Washington Post.
Counsel,
Sonia Sotomayor.
let me break this down. I understand your argument that there is a First Amendment right that the U.S. company has. I'll go that far with you, okay?
I'll take it.
Because we're affecting their ability to talk in whatever way they choose. The Washington Post could choose without any influence or threat against the children of Mr. Bezos to promote Chinese policy, and our First Amendment would permit them to do that if they chose it independently, correct?
Yes.
Now the question becomes, so it's not, that's just a given that they have a First Amendment right. The next question is, assuming they do, what's the level of scrutiny we apply? Isn't that what the issue here is?
That is certainly one of the issues, Your Honor.
All right. So if we get to that side of the issue, that TikTok USA has some sort of First Amendment right, taking your example, if the government said no speaker is free to speak under a criminal compulsion by someone else because of extortion, because of kidnapping, we are doing this because it is the only way to ensure the safety of people, that they are not going to be kidnapped or threatened, their lives threatened. You don't think that the government has a compelling state interest in saying if there is a threat, a physical criminal threat against someone to do some activity, that the government couldn't say, I'm not questioning whatever the content is of that activity. I'm simply saying we, in our governmental powers, have a right to say, you can't do that. You can't speak.
Sure, Your Honor. So, to take your question in pieces, I do think that they would have a compelling interest in that scenario to do something. But what I don't think is that they could simply target speakers in speech. Take, for example, generally applicable laws like the
So you think in that situation that the only thing the government could do is tell the Washington Post, disclose to the public that you are saying this because you are being forced to?
So
That's the only remedy the government could undertake?
No, Your Honor, but I want to make sure I understand the hypothetical. The compelling interest is in preventing this kind of compulsion, coercion, and ultimately harm to children. And I think that the government has a lot of different ways they can address that through speech-neutral laws. And I was going to point to things like the Trading with the Enemy Act or Russia sanctions. You can broadly say and attack problems.
They haven't been very effective.
Well, be that as
we're still having people kidnapped. We're still having coercion.
And be that as it may, you can say to Americans, you cannot collaborate with our enemies at all. And if you do that, you're going to be severely punished for doing
All
that.
right, we can go on to the effectiveness of the remedy. But the point is, I believe that even if your First Amendment rights are impinged and there is some protection, the question is at what level of scrutiny?
Yes, Your Honor.
And whether that the action is content neutral or not.
I agree that is the way that the analysis proceeds. Here, we believe that the level of scrutiny should be strict scrutiny.
What is the relevance of the history? Chief Judge Srinivasan, in his opinion, in the D.C. Circuit, emphasized that there is a long tradition of preventing foreign ownership or control of media in the United States, going back radio, television, and what have you. I would think no matter the level of scrutiny, that history has to be important, and I want to get your response to it.
I don't actually think it's important in this context because that history all arises in the context of bandwidth scarcity. And in that context, you have the government that's in the position of doling out a limited number of licenses. And when you have to dole out a limited number of licenses, you by definition have to pick winners and losers. And when you have to do that, you get a certain amount of discretion. I think that's the whole basis of those cases. You can't really take those cases
keep going.
You can't really take those cases and extend them to an area where there is no scarcity like the World Wide Web, because once you do that, there's really no limiting principle. There's no reason why it wouldn't also apply to really popular books or magazines or newspapers or chains of newspapers. The bandwidth scarcity, I think, is really what justifies the greater discretion that the government gets in that area.
Mr. Francisco, let me see if I can break this down. Suppose that TikTok were outright owned by the People's Republic of China. Would you make the same argument?
I wouldn't be making the same argument, Your Honor.
Why not?
Because there you would have to confront a very different question, whether a foreign government that was speaking in the United States has First Amendment rights, and I don't know that the court has ever addressed that. But here we've got a U.S.
No, I understand that. I just want to see where you draw the line. So it's true, the court has never held that a foreign government has free speech rights, and if we were to hold that, I would think it would be because speech by a foreign government, particularly one with enormous resources, is not protected. Allowing that does not serve the underlying interests of the First Amendment, which are, among other things, fostering democratic self-government and furthering the search for truth. So let's assume we start with that, all right?
That's Justice Samuel
What
Alito.
if TikTok were then not owned by the foreign government, but it was undisputed that TikTok was totally controlled by the foreign government, could not do one thing without the approval of the foreign government? That's different?
I do think that it is different, Your Honor. For example, I've given the hypothetical that I've given, but there are a lot of companies in this country that have foreign owners, not just companies like Politico, which is German-owned, or Al Jazeera, which is partly owned by the government of Qatar.
Well, I understand that, but what would be the reason for drawing that line?
Sure,
because there's a good reason for saying that a foreign government, particularly an adversary, does not have free speech rights in the United States, why would it all change if it was simply hidden under some kind of contrived corporate structure?
Because it is a U.S. speaker. I'll give you another example. AMC movie theaters used to be owned by a Chinese company. Under this theory, Congress could order AMC movie theaters to censor any movies that Congress doesn't like or promote any movies that Congress wanted. And I think the reason is that here, where it's conceded, you actually have a bona fide U.S. company. It is not simply a Chinese cutout that is the Chinese government speaking itself.
All right, let's say that's not a
United States company.
Let's say this is not a complete answer to your First Amendment argument, but would you be willing to concede that this is a very important factor that should be taken into account in deciding whether there's a First Amendment violation?
Well, Your Honor, I think that it does help supply a compelling governmental interest, but I still think you have to march through the strict scrutiny analysis and analyze their interests. I do not think that they have a compelling governmental interest in the manipulation of content. I think that is in the teeth of the First Amendment, and if you look at the government's brief and the rest of the record in this case, that's really what it's focused on. Their complaint is the fear that the content could be critical of the United States government or could undermine our democracy. Yes, Your Honor.
Mr. Francisco, I just wanted to follow up on that line of questioning with just some fact questions, because it seems to me there are a couple of things that the parties still dispute about facts in this court, which is a little unusual. The government says that TikTok US has no authority or ability to alter the algorithm or recommendation engine, but must simply follow ByteDance's directives. You disagree with that in your reply brief.
Yes,
somebody has to be right and somebody has to be wrong about that. What's the fact? What does the record show?
Well, Your Honor, we are here on a record, and there is nothing in the record that says that TikTok, like any other subsidiary, doesn't have its own independent making authority. If you look at their record sites, what they point to is the ordinary types of control that a parent company has over a subsidiary company, but it doesn't change the fact.
All right, what is the fact? Are you prepared
Justice
to make
Neil
a representation?
Yes, Your Honor. The fact is that TikTok Incorporated, as a U.S. company, does have a choice over the algorithm. Now, it would be an incredibly bad business decision for them to abandon this algorithm, and they very doubtful would ever do it, but they have that authority. What they clearly have the authority to do is shut down the platform in the face of Chinese pressure. That's actually what they agreed to do in the National Security Agreement. I think that underscores why TikTok Incorporated, as a U.S. company, does have its own set of First Amendment rights.
Okay, and then another fact question. Before the D.C. Circuit, you argued that the Chinese government has made clear in public statements that it would not permit a forced divestment of the recommendation engine. Does that mean that some key component of the recommendation engine is under Chinese control?
No, Your Honor. What it means, and this might warrant a little more explanation, what it means is that there are lots of parts of the source code that are embodied in intellectual property that are owned by the Chinese government, and they would restrict, like the United States restricts the sale of those types of things to foreign governments. It doesn't alter the fact that this is being operated in the United States by TikTok Incorporated.
Okay.
So,
I got it.
Okay.
I got it. And then you represent that the divestiture is not feasible within the Act's time frame. I'm sorry for these fact questions.
Sure.
I just want to understand what's before us. Would it be feasible in any time frame? I take the government doesn't dispute that it's infeasible in the 270 days provided by law. But would it be
Your Honor, I think, at least as we understand how they've interpreted the qualified divestiture provision, it would be exceedingly difficult under any time frame for two principal reasons. The first is that there's a global team of engineers that are some in China, some in Europe, some in the United States that maintain and update the original source code. And as we understand their interpretation, a qualified divestiture would prohibit any kind of coordination with that global team of engineers. The other reason is because, as we understand how they're interpreting it, a qualified divestiture would divorce the U.S. platform from the global content. So, for example, there are videos created in the United States, there are videos created in Ireland. In order to get global content, we need access to the Irish videos. They need access to the U.S. videos. We understand that couldn't happen.
Okay, so you think it's probably not feasible in any timeline?
Well, Your Honor, I think it'd be extraordinarily difficult.
Okay, last fact question, then I'll yield the floor here. The government admits that it has no evidence that TikTok has engaged in covert content manipulation in this country, but says that ByteDance has responded to PRC demands to censor content outside of China in other countries. Again, you deny that in your reply brief. Somebody has to be right about that.
Well, Your Honor, the problem there is everything that follows what you just read is redacted, and so I don't know what it says. What the record shows is two things. The record shows, first, what you just said. They haven't done anything here in the United States with respect to TikTok Incorporated. And second, the record also shows through our transparency reports that we haven't removed or restricted content on the TikTok platform in other parts of the world. And TikTok doesn't operate in China, it operates in other parts of the world. We haven't removed or restricted content at the request of China. That's what we put out in our regular transparency
removed
reports.
or restricted, though, doesn't necessarily cover covert content manipulation, though, right?
Well, Your Honor, I'm limiting my response to what's in the record.
Okay.
It's very difficult for me to respond to things that I don't know what the accusation is.
I have other questions about the secret evidence in this case, but we'll get to that later.
Yes, Your
Mr.
Honor.
Francisco, can I ask you a question about the relevant speech here? So it strikes me that this is a little different than your Bezos example, because there it's clearly content discrimination because we're talking about the ability to post particular articles versus other articles.
Justice
Am I
Amy
right
Coney
that the
Barrett.
algorithm is the speech here?
Yes, Your Honor. I would say the algorithm is a lot of things. The algorithm has built within it. It's basically how we predict what our customers want to see.
The editorial discretion.
Yeah, the editorial discretion. It also has built within it the moderation elements. All of this kind of comes together when the source code is translated into executable code in the United States. In the United States, that executable code is then subject to vetting, review, moderation through content moderation algorithms, and so it ultimately lands on the TikTok platform.
But what we're talking about as a NetChoice is the editorial discretion that underlies the algorithm. And I just want to be clear, a lot of your examples talk about, including the Bezos one, the right of an American citizen to repeat what a foreign entity says or say, I'm hitching my wagon to China, I want to say everything China does. Here, the concern is about the covert content manipulation piece of the algorithm. That is something that ByteDance wants to speak, right?
Well, Your Honor, I think that ultimately it's TikTok's choice whether to put it on the platform.
And you don't want that. Is your client disclaiming
we absolutely resist any kind of content manipulation by China at all. But what I do want to focus in on is what their asserted interests here. They do talk about covertness, but it can't possibly be that all they're concerned about is mere covertness. If all you were concerned about was the covertness untethered from the underlying content, that's something that could be easily addressed through a risk disclosure.
But that goes to scrutiny, the level
Yes, Your
of
Honor.
the application. Let's say that I agree with you, the First Amendment is implicated, and I'm trying to figure out what level of scrutiny applies, and I'm trying to figure out what content, if any, discrimination is going on here. There's a disproportionate burden. Let's say that I agree with you about that. No one is preventing you. You're seeking access to a particular source code, engineering, the recommendation feature. It's the technology that you want. You're not trying to repeat, as in the Bezos example, if we take the speech that the government's concerned about to be the covert content manipulation rationale, you're not seeking to utter that speech.
That's correct, Your Honor. What we are seeking to do is use an algorithm that displays the combination of content that we prefer our users to see on the platform.
And the government doesn't care about that. I mean, the government is fine with you doing that. You can invent it yourself. It doesn't even care what content that displays, cat videos or whatever.
Yeah, but I think that the way that the analysis has to unfold is first you ask, is this law burdening our speech? I think we agree that the law is burdening our speech. Then you have to look at whether the law itself is somehow content-based, not just what their motivations are, but whether the law is content-based. And here, the trigger for this law, the one thing that gets it going is if you operate a social media platform that has user-generated content, unless that content takes the form of a product, travel, or business review. Then within that universe of content, it says there's one speaker we're particularly concerned about, and we're gonna hammer home on that one speaker. And then just to make the rubble bounce, they come in and tell us that one of the reasons they're targeting that speaker is because they're worried about the future content on that platform, that it could in the future somehow be critical of the United States or undermine democracy, to pull examples from the government's brief. So I think there's no way to get around the fact that this is a content-based speech restriction, and you do have to go directly to what their interests are.
Well, that is the attorney for TikTok, Noel Francisco, and we're hearing the arguments from TikTok at the U.S. Supreme Court, which happened last Friday, and it could be as early as Sunday that this happens, where TikTok will be banned in the U.S. Well, let's jump ahead in these 2 hours of arguments and hear from the Solicitor General of the United States. Her name is Elizabeth Prelogar, and she was answering questions Friday by U.S. Supreme Court justices about the TikTok ban that goes into effect on Sunday. Here is the Solicitor General of the U.S. answering questions from the U.S. Supreme Court justices. This is WMNF Tampa.
Mr. Chief Justice, and may it please the court, the Chinese government's control of TikTok poses a grave threat to national security. No one disputes that the PRC seeks to undermine U.S. interests by amassing vast quantities of sensitive data about Americans and by engaging in covert influence operations. And no one disputes that the PRC pursues those goals by compelling companies like ByteDance to secretly turn over data and carry out PRC directives. Those realities mean that the Chinese government could weaponize TikTok at any time to harm the United States. TikTok collects unprecedented amounts of personal data, and as Justice Sotomayor noted, it's not just about the 170 million American users, but also about their non-user contacts who might not even be engaging with the platform. That data would be incredibly valuable to the PRC. For years, the Chinese government has sought to build detailed profiles about Americans, where we live and work, who our friends and coworkers are, what our interests are, and what our vices are. TikTok's immense data set would give the PRC a powerful tool for harassment, recruitment, and espionage. On top of that, the Chinese government's control over TikTok gives it a potent weapon for covert influence operations. And my friends are wrong to suggest that Congress was seeking to suppress specific types of content or specific types of viewpoints. Instead, the national security harm arises from the very fact of a foreign adversary's capacity to secretly manipulate the platform to advance its geopolitical goals in whatever form that kind of covert operation might take. The Act addresses the threat of foreign adversary control with laser-like focus. It requires only divestiture of TikTok to prevent Chinese government control. And that divestiture remedy follows a long tradition of barring foreign control of U.S. communications channels and other critical infrastructure. So no matter what level of First Amendment scrutiny applies, this act is valid because it's narrowly tailored to address compelling national security threats. Now, my friend Mr. Fisher just emphasized, and I acknowledge, that millions of Americans enjoy expressing themselves on this platform. But the important thing to recognize is that the act leaves all of that speech unrestricted once TikTok is freed from foreign adversary control. The First Amendment does not bar Congress from taking that critical and targeted step to protect our nation's security. I welcome the court's questions.
Is there any difference between content manipulation by a non-U.S. company as opposed to a U.S. company? I didn't hear Mr. Fisher make a distinction between the two.
Yes, and I think the important thing to recognize is that the act here is targeting covert content manipulation by a foreign adversary nation. Now, I understand my friends to
What
say...
What difference does that make?
The difference is that there
Clarence
is
Thomas,
no protected First Amendment right for a foreign adversary to exploit its control over a speech platform.
The difference between covert and non-covert.
So I think that Congress's concern with the covert operation was that a foreign adversary could effectively weaponize this platform behind the scenes in order to achieve any number of geopolitical goals. Here are some of the examples that come to mind. One of the pages out of the playbook here is for a foreign adversary to simply try to get Americans arguing with one another to create chaos and distraction in order to weaken the United States as a general matter and distract from any activities that the foreign adversary might want to conduct on the world stage.
What do you mean by covert, though? I mean, is covert just mean it's hard to figure out how the algorithm works? Because we could say that about every algorithm.
No, the covert nature of it comes from the fact that it's not apparent that the PRC is the one behind the scenes pulling the strings here and deciding exactly what content is going to be made to appear on the site. And another way that the
It's just because we don't know that China's behind it? That's what covert means?
Well, I think
it doesn't have anything to do with the difficulty of figuring out what the algorithm is doing. It's just because people don't know that China is pulling the strings. That's what covert means?
What it means is that Americans are on this platform thinking that they are speaking to one another, and this recommendation engine that is apparently so valuable is organically directing their speech to each other. And what is covert is that the PRC, a foreign adversary nation, is instead exploiting a vulnerability in the system.
Well, if that's all it means, that like people don't know that China's behind it, like everybody now knows that China is behind it.
No, but it's the specific content that's being manipulated would be unapparent. And so I think
that's true of every search engine. I mean, you can take any of these algorithms, whether it's X or whether it's, you name it. What are the new ones? Blue Sky? I mean, none of these are apparent, right? You get what you get and you think that's puzzling. And it's all a little bit of a black box. So you can't just mean it's a black box, it's covert. They're all black boxes. And if you just mean what's covert is the fact that there's China behind it, I mean, honestly, really, like everybody does know now that there's China behind it. So I just don't get what this covert word does for you.
I think the problem with just saying as a general matter, China has this capability and might at some point be able to exercise it and manipulate the platform is it doesn't put anyone on notice of when that influence operation is actually happening, and therefore it doesn't guard against the national security harm from the operation itself.
Isn't that a pretty paternalistic point of view? I mean, don't we normally assume that the best remedy for problematic speech is counter speech? And TikTok says it could even live with a disclaimer on its website saying this can be covertly manipulated by China. In case anybody were left in doubt after today about that possibility. So you're saying that won't work because?
That won't work because it is such a generic, generalized disclosure that it wouldn't put anyone reasonably on notice about when it's actually happening. And the example I've been thinking about is...
argument is that the average American won't be able to figure out that the cat feed he's getting on TikTok could be manipulated, even though there's a disclosure saying it could be manipulated.
But imagine if you walked into a store and it had a sign that said 1 of 1 million products in this store causes cancer. That is not going to put you on notice about what product is actually jeopardizing your health. And I think that's roughly equivalent to the type of disclosure they're contemplating here. They brought up the example of the Foreign Agents Registration Act, FARA. There you have to disclose the actual content.
If that's true, then wouldn't that be true for all social media companies, for all content? I mean, every editor, every newspaper in its editorial room makes decisions about what it's going to run and how it's going to say it. And every algorithm has preferences, whether it's domestic or foreign. And nobody really knows exactly when those editorial decisions are being made or how. But they're generally aware, and we think that's enough.
I think, though, that there is a real risk that when a foreign adversary has control of that kind of mechanism and a speech platform in the United States, it could weaponize that platform to harm United States interests. And one of the key ways that the PRC flexes this muscle is to suppress speech.
General, I'm sorry to interrupt you, but we're not arguing about the compelling interest. We're arguing about the tailoring.
Right. And so I guess what I would say, you began by saying the cure for concerning speech is counter speech. Here, I dispute the premise that Congress was specifically concerned about any particular subject or any particular viewpoint. It wanted to close off a capability of a foreign government. But in any event, it's very hard to engage in counter speech when you don't know because someone is secretly manipulating the platform behind the scenes. And in particular, what the PRC has the capability to do is simply silence American voices.
With a newspaper owned by a foreign company and a foreign government, you wouldn't know when it's exercising editorial discretion about this article or that article or how it's doing it. So maybe we just need to shut down the Oxford University Press in America, or you pick it, any other foreign-owned Politico, I was told today, is owned by Germany.
So
that would all be okay on your theory so long as Congress designates that country a foreign adversary?
We are not asking the court to articulate bright line rules to govern all kinds of hypothetical situations.
I am testing your argument.
Yes, and what I want to acknowledge is that sometimes the court has recognized that a speaker-based preference might reflect a content-based preference. And in the context of ownership of a newspaper, for example, in part because a newspaper is a one-way channel of communication and is generally understood to represent to some extent its publisher's views, maybe the court would more readily infer that a regulation targeting that is actually aiming to target content. But I don't think the court could draw the same conclusion here.
I'm not talking about the compelling interest or any of that. I'm talking about the tailoring. And you're saying we have no alternative but to stop this speech altogether. We can't rely on disclosure. But you say that wouldn't apply to Politico or to the Oxford University Press because?
In the circumstance where you have a newspaper that is understood to reflect its publisher's views, then you might think that disclosure would be a more adequate remedy there because it's not just holding itself out as a forum for speech between other people. I think social media platforms do raise distinct interests in this regard because what people think when they're engaging with TikTok is that it's organically feeding them videos based on the recommendation engine. And if actually China is behind the scenes engaging in this kind of covert operation, it does prevent a distinct national security risk. Of course, the other big difference with the newspaper is it's not likely to be collecting sensitive personal information about 170 million plus people and then having the capacity to send that back to a foreign adversary.
General Prelogar, can I? Oh, go ahead.
I was just going to say, did I understand you to say a few minutes ago that one problem that ByteDance might be through TikTok trying to get Americans to argue with each other?
That it might be just trying to foment
disruption. If they do, I say they're winning.
Or dissent. That might very well be true, Mr. Chief Justice. And I think the point I'm trying to make is that China is a foreign adversary nation that looks for every opportunity it has to weaken the United States and to try to threaten our national security. And if it has control over this key communications channel, it's hard to predict ex ante exactly how it's going to use that as a tool to harm our interests. But we know it's going to try, first and foremost, by seeking to get the data of these American users, which would be of a piece of all of the activity the PRC has already undertaken to breach our laws. Hack OPM, for example, and exfiltrate the background files and security clearances of 20 million government employees, the breach of Equifax to get sensitive financial data, Anthem to get sensitive healthcare data. We know that the PRC has a voracious appetite to get its hands on as much information about Americans as possible, and that creates a potent weapon here because the PRC could command that ByteDance comply with any request it gives to obtain that data that's in the hands of the U.S. subsidiary.
Thank you.
General Prelogar.
Suppose that TikTok had no connection whatsoever with any foreign government. It was owned instead by an immensely rich multinational corporation, and Congress concluded that this multinational corporation really has it in for the United States and is going to use this extremely popular platform to do everything it can to undermine the United States in all the ways in which you think that TikTok may pursue at the direction of the PRC. Would that be the same case?
I think there would be a first-order question of whether the multinational corporation itself has First Amendment rights.
All right, it's an American corporation.
So if it were an American corporation, I think that, and Congress disagreed with the viewpoints or content the corporation would display, obviously that's a direct regulation of protected speech and it would trigger strict scrutiny. I think that's different in kind from what Congress was worried about here, which was not regulating speech as such, but instead regulating foreign adversary control.
So your argument depends on the fact that what is at bottom here is the People's Republic of China using TikTok. That's what your argument depends on. If this were an American corporation, it'd be an entirely different thing.
Exactly. And the reason we know the statute is different is because all of the same speech that's happening on TikTok could happen post-divestiture. The Act doesn't regulate that at all. So it's not saying you can't have pro-China speech, you can't have anti-American speech. It's not regulating the algorithm. TikTok, if it were able to do so, could use precisely the same algorithm to display the same content by the same users. All the Act is doing is trying to surgically remove the ability of a foreign adversary nation to get our data and to be able to exercise control over the platform.
I'm sorry.
This is Justice
I just
Elena.
wanted you to respond to Mr.
Sorry, this is
Fisher's
Amy Coney
argument
Barrett.
about the rights of Americans to receive information, say, from the PRC or anyone else, and that even if ByteDance did not itself have First Amendment rights, that Americans would have a First Amendment right to receive that information in the Lamont sense.
Yes, so I think that Lamont reflected a principle that there can be a right of American listeners to receive information, and if Congress is directly regulating that based on disagreement with the speech that's being sent into this country, that's obviously going to trigger heightened scrutiny under the First Amendment. But here, I think the users have to be asserting a different type of interest, because what Congress was safeguarding against was not the ability of TikTok to continue to operate or the users to post content. It was focused only on foreign adversary control. And so the users would have to demonstrate that they have some unqualified First Amendment right to post on a platform that's controlled by a foreign adversary, which could use that access to then threaten our nation's security by gathering data on tens or hundreds of millions of Americans, and also use it for covert influence operations of whatever form. And I don't think there's a First Amendment right to do that.
I was trying to think of whether there's a historical
Justice
analog
Elena
here,
Kagan.
and this is what I came up with, and you can tell me whether it's fallacious. In the mid-20th century, we were very concerned about the Soviet Union and what the Soviet Union was doing in this country. And the Communist Party of the United States at that time was integrally attached to the Communist International, which was essentially a Soviet operation, right? So if Congress had said, oh, it's very nice, we can have the Communist Party USA, but it has to divest, it has to completely divorce itself from the Comintern and from any international ties that it has, do you think that that would have been absolutely fine? And so if the answer is yes, it would have been fine, it's just like this case, or if the answer is no, why is it not like this case?
So I guess I think I would need to know more information about how the international organization is able to exercise control over the American affiliate. And if it had the capacity, for example, to, in an unqualified fashion, gather data from that affiliate in a way that was going to jeopardize our nation's security.
Well, I'm talking more about sort of the content. Let's put the data collection piece of this aside, which seems not very pertinent to my 1950s analog. But very concerned about the kind of speech that the Communist Party was making in the United States, and it turns out that content was pretty well scripted someplace else.
I think if it was specifically a concern about the content, then that would trigger heightened scrutiny under the First Amendment. We're not trying to run away from that principle here. Instead, we're making, I think, a narrower argument.
Well, then I think that you're a little bit, I think you've just given your thing away, because content manipulation is a content-based rationale. We think that this foreign government is going to manipulate content in a way that will that concerns us and may very well affect our national security interests. Well, that's exactly what they thought about Communist Party speech in the 1950s, which was being scripted in large part by international organizations or directly by the Soviet Union.
I disagree that the concern with covert content manipulation is itself content-based, or that it looks anything like the kinds of laws this court has previously said are content-based. The court most recently in City of Austin said you only have a content-based law when Congress is setting out to discriminate against particular subject matters or particular viewpoints. So it's not enough that the law is regulating in the space that involves content in some way. You have to have this motive by Congress to actually want to suppress speech on certain topics or certain viewpoints viewpoints. Here, Congress just wants to cut the PRC out of the equation altogether, and all of the same speech could continue to happen on the platform. It's like patching up a backdoor vulnerability that the PRC has that we can't totally see around all the corners to imagine how it could use it against our interests, but we know the PRC will do whatever it can to try. And I think that is different in kind from imputing to Congress some motive to specifically get more speech on certain topics or with certain viewpoints. This law was passed by broad bipartisan majorities in both houses of Congress, and our legislators don't always agree on everything. I think it's unlikely that all of them had exactly the same views about what's good content on TikTok or what are good viewpoints. They weren't united on that. What they were united around was the idea that it is a grave threat to our nation if the PRC can itself behind the scenes be controlling how this platform operates.
Why doesn't this act classify on the basis of speaker?
I do think that when it comes to the PRC and ByteDance, you could treat this as a speaker-based restriction.
And aren't speaker-based restrictions almost always viewpoint-based restrictions, content-based restrictions?
The court has said it depends. It hasn't applied an inflexible rule that any time you are regulating certain speakers, you are invariably regulating based on content. Instead, the court has said it warrants closer consideration. And here, if you look at the U.S. speakers, TikTok US and the users, none of them are being regulated in a way that suggests it's disagreement with their content. It's all about what our foreign adversary is doing.
It's hard for me to think of situations, maybe they exist, where our classification based on speaker is not viewpoint or content-based restrictions. I mean, that somebody says, Joe can't talk anymore. We're going to shut Joe up. And we don't know what he's going to say tomorrow or 2 weeks from now. We don't know what he's going to discuss, but whatever he says is bad because Joe is a bad person. I mean, that's viewpoint and content-based, isn't it?
I think when it comes to a foreign adversary, it's not right to view it that way. And the reason for that, again, is this is a sophisticated adversary nation, and we can't just simplistically say, oh, what the PRC is going to want is to see more pro-China content on this app. As Chief Judge Srinivasan observed, there are various ways that the PRC could try to create some kind of false flag operation and actually promote anti-China content, not to dictate how Americans should think about things, but simply to create some trumped-up justification for a military or economic action that the foreign adversary wants to take against us. And I don't think a concern with trying to ward off that capability.
Why isn't that viewpoint or content still? We don't know what the content's going to be, but we know it. Joe is bad.
Because I think the better classification is to recognize that what we're trying to prevent is not the specific subject matter, the specific viewpoints, but the technical capability of a foreign adversary nation to use a communications channel against this.
I guess I'm just struggling how covert content manipulation isn't content-based restriction.
So again, it's because
it's kind of hard to avoid the word content, and it's kind of hard to avoid the word viewpoint here, isn't it?
I don't dispute that it's related to content, but I don't think it reflects Congress seeking to set out in advance what kind of speech we should have reflecting certain views on certain topics. Instead, it's about trying to close off a vulnerability that our foreign adversary nation could exploit. And I would be remiss if I didn't point out that even if you thought this was content-based, all that means is that we're in strict scrutiny, and as the D.C. Circuit recognized here, we think that this law serves compelling national security concerns that sound in some of the same arguments I'm making here and that have a long-standing correspondence to history and tradition of trying to prevent foreign control.
And then we get to the question whether there's a less restrictive means. I get that, and whether disclosure might suffice. On the data security point, your friends on the other side make the argument that if that were the concern, Congress could ban TikTok US from sharing data with anyone on pains of penalties that would put people in prison and shut the company down in the future, as the government did, for example, with Arthur Andersen. Why isn't that a less restrictive means available?
So I was surprised to hear petitioner offer that up today because there was a long course of discussion between the executive branch and ByteDance and TikTok leading up to Congress's enactment of this act that spanned over 4 years. an extensive conversation about what limitations could be placed to protect Americans' data. And it was never a suggestion that there would be any way to create a true firewall that would prevent the U.S. subsidiary from sharing data with the corporate parent. And the reason for that sounds in the technological features of this application. I think there can be no reasonable dispute that the source code development and the maintenance of this algorithm rests in China, which is why China has sought to try to control export restrictions with respect to the algorithm. And what that means is you need substantial data flows between the companies in order to continue to modify that algorithm, refine it, and so forth. So I don't think that that was an option ever on the table, including with respect to the proposed national security agreement that was insufficient in protecting our data privacy and security concerns.
That didn't come
Justice
across
Sonia
enough
Sotomayor.
in the briefs. If we are in the world of data protection as opposed to content control, I think it's hard to get around the post-divestiture provision that says you can't do business with them on the algorithm, because that very much is content-based. It's a content-based restriction. But what you're saying is you can't do it for a data control reason, meaning that you can't really run their algorithm without sharing the very data that we are concerned about as a threat, correct?
That's right, Justice Sotomayor, and you don't have to take my word for it. You can look at the specific terms of the National Security Agreement that ByteDance itself proposed. The relevant definition of the accepted data is at JA 239 to 240, and it references categories of information that would, of necessity, technological necessity and business necessity, have to flow back to China. And the relevant categories are in the sealed appendix, but I would really encourage the court to look this up because it's eye-opening. It is at the Court of Appeals sealed appendix 249 to 252 and 254. If you look at that information, it was a wealth of data about Americans that was going to have to go back to China in order for the platform to just continue its basic operations. And there's a legitimate commercial justification for that, but it creates this gaping vulnerability in the system because once that data is in China, the PRC can demand that ByteDance turn it over and keep that assistance secret. And the one final point on this is that ByteDance was not a trusted partner here. It wasn't a company that the United States could simply expect to comply with any requirements in good faith, and there was actual factual evidence to show that even during a period of time when the company was representing that it had walled off the U.S. data and it was protected, there was a well-publicized incident where ByteDance in China surveilled U.S. journalists using their location data, this is the protected U.S. data, in order to try to figure out who was leaking information from the company to those journalists.
General, you want us to look at that.
Chief Justice
and
John
you get
Roberts.
to look at it, but your friends on the other side don't get to look at it. That doesn't seem fair.
That's the sealed appendix, Mr. Chief Justice, so it's their information. They can look at it. It's just under seal to protect their proprietary business information.
General, so I want to go back to the discussion about content discrimination, and we're going to shut Joe up. Here, it seems to me like we are saying to ByteDance, we want to shut you up. And so let's say that I think that that is content discrimination based on speaker. Tell me if I think that, tell me if I have to conclude that it is also speaker-based discrimination and content-based discrimination for TikTok.
No, it is not. And the reason for that is because it would be an anomalous principle to say that an entity outside the United States that can't assert its own First Amendment rights can somehow manufacture that right through the expediency of forming a U.S. subsidiary, especially one that it wholly controls.
So you don't have...
Well, that was U.S. Solicitor General Elizabeth Prelogar answering questions Friday by U.S. Supreme Court justices about the TikTok ban that goes into effect on Sunday. Well, I'm sure we'll hear a ruling on that before Sunday. It looks like most of the justices agree with the law that will ban TikTok. This has been WMNF's Tuesday Cafe. I'm Sean Kinane. If you missed any of the show or if you'd like to share it with a friend, you'll be able to find it on WMNF.org. I want to tell you about this great show I have coming up next week. It's a special show focusing on music. I'm going to interview May Pang about her upcoming exhibition in Tampa of photographs that she took during John Lennon's Lost Weekend. Plus, we're going to speak with Sarasota's Selby Gardens about two special exhibitions of theirs featuring George Harrison's work and Patti Smith's. So I hope you tune in next Tuesday at 10 and we'll rock and roll. In this time slot tomorrow is Midpoint. Coming up next is a special episode of Alternative Radio about health insurance featuring whistleblower Wendell Potter. It's an excellent show. I hope you stay tuned. And we're sad to announce that the hosts of Wavemakers are retiring. We'll spend the next couple of months trying to figure out what the best fit is for the 11 o'clock Tuesday slot. Coming up at noon today is Wide Awake America with Nadine Smith. Today she talks with Tim Mack, an investigative journalist currently reporting from Ukraine. Tim has launched what he calls the Counteroffensive. It's an independent Substack. This has been Tuesday Cafe, coming to you live on January 14th, 2025, from the studios of WMNF, Tampa, St. Petersburg, Sarasota, Lakeland, Clearwater, Bradenton, Newport Richey, and beyond. Thanks so much for listening and supporting Community Radio.